Good afternoon, everybody. My name is Carl Bauer. I am OPSC's Associate Executive Director, and I'm pleased to welcome you all to today's Lunch and Learn on professional physician contracts. Our presenter today is Kathy Nichols. She is Senior Healthcare Attorney at Carlson and Jayakumar. We are pleased to have her with us, but before I turn it over to her, I do want to go over just a couple of quick housekeeping items. First of all, please keep yourselves muted. I know everybody's in various work and home conditions. So as a courtesy to everyone else, please keep your microphones on mute. You're welcome to turn your cameras on if you'd like. If you have questions through today's presentation, do put them in the chat box. We will be monitoring those and trying to get those over to Kathy as they come up. If we don't, however, we will have an opportunity at the end as well to answer questions that you may not have thought of during the presentation. Other than that, I think we are good to go. Please note that this session is being recorded. It will be available on OPSC's YouTube channel at some point here in the near future, once we get the recordings and are able to edit some of the fluff at the beginning and the end. I don't have anything else to add right now, so let me turn it over to Kathy. Take it away, Kathy.
Thank you, Carl. Good afternoon, everyone. Thanks for having me. As Carl mentioned, I'm a healthcare attorney with Carlson and Jayakumar, and I'm going to go over some important we'll try to cover in under an hour what you kind of need to know on physician contracts. Obviously, I'm a lawyer. I'm not providing legal advice. I'm going to kind of give you an overview, and so I just have to kind of put that disclaimer in there from an ethics perspective. But just a little bit about me and my firm before I get started. We are a healthcare and an employment firm. I work on the healthcare side, but as we'll go over in this presentation, there's a significant overlap between healthcare and employment law, particularly with physician compensation, which is highly regulated. And so we do a lot of work in that space. We also provide advice and counsel on employment issues on the employer side. We do mergers and acquisitions and corporate governance for healthcare providers and healthcare companies. Along with that, we do regulatory licensing, whether that be Medicare or at the state level. We also work with a lot of hospitals and medical providers on operational and risk management issues. We handle a fair amount of licensing board cases. And so that's where we represent the provider, for example, the physician before the medical board or a nurse before the nursing board. We also provide counseling on issues such as HIPAA, which is the federal privacy law, Stark and fraud and abuse counseling, which we'll touch on those laws as well. And we also do a fair amount of work in the Medicare and insurance billing, private insurance and governmental payers in terms of audits and investigations on that end. So, and that's my particular expertise, kind of just went over that, but we represent physicians, medical groups, hospitals, healthcare companies, and kind of advise on kind of all the areas I just touched over. So on to today, what my goal is for you to have some takeaways on contract negotiations. So when you are presented with a contract, you have some knowledge on what areas to look at. It's always a good advice. It's always a good idea to get advice and counsel from a lawyer when you're looking through a contract. A lot of times contracts will say, you'll be signing saying that you did have the opportunity to consult with counsel. So it's always a good idea to run some of these physician contracts by a lawyer who understands the various nuances with them. So I will cover some, they're listed right here, the term, the compensation rate. I won't read through them all now because we're going to go through them, but it's an overview intended to highlight what you should be on the lookout for. So the first thing is the term, which is the length of employment. And kind of before we start there, kind of as a basis, the reason why we're talking about contracts in the employment context is a good question, because generally most employees are what we call at will, which means you get offered employment you start working there, and you can kind of be let go of any time. Not for, a discriminatory or wrongful termination reason. There's a whole host of laws that govern that, but you can be let go for just, performance reasons, or we're closing this operation, or we're changing the staff, or really no reason at all, as long as it's not illegal. That's at will. And the employee similarly can say, you know what, I'm getting a new job, I'm going to work somewhere else, or I've decided I'm not going to work here anymore. You don't need to give a reason. So that's where either side is at will. That's what that means. And so the reason why that's important is because the distinction is, for physician compensation, one of the big rules in order to meet the regulatory requirements that are required is that there needs to be a bona fide employment relationship, and that typically is documented, which means writing, with an employment contract. So physician compensation, which means how physicians are paid, is regulated at both the federal and state level. So the federal level, the most common is the Ethics in Patient Referrals Act, otherwise known as STARK, which I kind of alluded to before, which regulates physician referrals. And that's for designated health services, which are certain services. There's a whole spreadsheet on that I won't go into, but California also has its own version, which isn't designated health services. So typically a healthcare lawyer will advise you to comply with the law, even if some of the services you're not providing don't fall within that federal list. And then there's another federal law called the Anti-Kickback Statute, which covers everyone, not just physicians. And it's a very broad statute, and it covers all types of services as long as they're paid for by a governmental payor. And most states have a state version of that as well. So you can't sort of get around it by saying, well, I'm not going to take, federal money. Usually the states have most states have a similar requirement. So because of these state and federal statutes that govern how physicians are paid, you typically have an employment agreement that documents what the payment is and how that's being arranged. Basically, what is the compensation and what is the physician being compensated for? So many businesses, non-healthcare, have all types of transactions, relationships based on, well, you bring in more business, we pay you more. And so there's a lot of different arrangements that in the normal business context, the non-healthcare context, are perfectly legal. But once you apply them to physician compensation or to a healthcare transaction, they can be illegal. And these statutes, particularly the kickback statute, carry up to criminal penalties. So the penalties for these laws can be as small as either not getting paid for your services, up to civil monetary penalties, up to criminal, which would include, prison time. So it's really important to understand which of these apply and to make sure that your contract complies with that. So the term, just to kind of recap here, is the length of employment, which typically, to qualify under the federal and state laws, they literally have tens of probably 50 or more exceptions to them, because transactions between healthcare providers are so complex and these laws are so robust. So there's a lot of exceptions and they change all the time. And we won't have time to get into all of them today, but one of the exceptions is to have a bona fide employment relationship, which is documented in an employment agreement, and the term would need to be at least one year. Now, if the parties needed to end it earlier because someone moved or something, there's always an exception like that, but you want it documented that the intent was for 1 year. Just move. And early termination. So this is an issue that I bring up, especially for physicians that are new in their career, because one of the things you want to think about when you're entering into a 1 year commitment, or maybe it's even a 2 or 3 year commitment, is what does the exit look like? So even though you're maybe excited to start a new job, the exit is something that's important, because a lot of times there's a notice provision, and that's sort of in this last comment here, the notice provision, which requires the parties to give each other sort of a heads up that they're ending the deal. So I had a client one time where she was a physician for a medical practice, and she had a 6-month notice period, meaning she had to give 6 months notice before she left, which is a pretty long period. A lot of times they're about 60 days is what I see, 60, maybe 90 days, but 6 months is a long time. And she sent an email to her employer saying, effective such and such date, I'm going to be leaving. The employer tried to say later on, well, because they couldn't find someone to replace her, oh, well, we didn't get the notice. So luckily she had proof of it and we were able to negotiate her exit. But it's really important, and we'll go over this in the next slide, that the notice that you give that you're leaving is sent to the right person, is sent in the proper format. And the termination can also be for cause, which is the second term, which is basically there's something that triggers the termination. That's either on the employee side, so it'd be the physician, or the employer side, which would be the medical practice. And I'm kind of using that as an example because that's the most common relationship I see, is the medical practice with a physician. So in that context, the employee physician does something, either loses their license. That's usually a cause for immediate termination of the contract. Or sometimes there's really vague provisions that say doesn't meet the standard of care. And so, well, what is the standard of care for that particular physician? And so the employer may try and say, well, you haven't documented your patient care well enough, or something like that. And so there's typically, most of these contracts have clauses in them that explain what triggers termination. So you want to make sure you look at those to know what that is. And then kind of turning back to the no cause termination. So this is the most common, where you've decided you're going to be, either you're moving or you're going to just go to another position. And so you need to make sure that you give the proper notice, because if you don't, you could be forced to pay kind of whatever's left on your contract, which could be several $1,000s. Now, I have seen where the new practice that the physician's going to is willing to buy out the doctor because they want to bring that doctor on pretty quickly. That's something that a lot of times can be negotiated if the current employer agrees to that. But it's basically the notice provision in there to protect the employer. And you'll see and maybe have familiarity with employment agreements, they tend to be much more in favor of the employer. The employer is usually drafting them. Employees don't usually draft them. And so this is one of those provisions that's in the employer's favor. And it's so the employer is sort of not left in a pinch without a physician, and they have these patients, and what's going to happen. And so that's why they usually require, 30 is pretty short, but usually about a 60-day, sometimes a 90-day. And like I said, I had one client with a 6-month. So that's, when you're entering into a contract, that's one thing you can think about negotiating, is if there is a 6-month termination provision, see if you can shorten that. And again, you can always negotiate after you've entered into the contract if the employer is willing to do so, and see if you can shorten that period. But it's always good to know ahead of time what your requirement is, because it's most likely the employer is going to follow the contract and isn't going to let you skip out early unless you either pay them, or possibly you bring on someone new that can take your place. In this second part here, that can't re-enter deal until the end of the 12 months. This is if you end your relationship with the employer within that 1-year period, you have to wait until after the end of that 1-year period to re-enter the deal, because of that 1-year requirement. And the reason why is because under federal and state anti-kickback and anti-referral statutes, which I alluded to before, they want you to have that 1-year term. So they don't want you entering into a contract for 3 months. Oh, and then you realize, well, we should be paying this doctor more. Let's end the contract, enter into a new one that's a 1-year contract. You can't try and get around the 1-year rule, is basically what that rule is intended, that requirement's intended to enforce. Okay, so let's talk about the compensation It's best to use a fixed pay that's set in advance. And so again, the requirement that compensation be documented is based on the premise, and these anti-referral, anti-kickback statutes are designed or focused on combating fraud and abuse. And so one area that was seen before these statutes came into effect many years ago was physicians being paid based on referrals. So maybe even patients they didn't see, they referred it somewhere else, they were getting paid for that. And so that's what these statutes are designed to they combat against. And so a percentage is not fixed. Those are allowable in California. There's exceptions to a lot of these rules. And so there are ways to compensate providers who do a good job. So this provider, sees a lot of patients, brings in a bigger volume of business. There's ways to structure, we call them bonus pools, and there's ways to structure rewarding providers who perform better, right? So there are ways you can kind of put that together. The other thing about compensation is the benefits are also the compensation. So one way that some practices and hospitals and other providers or employers have tried to get around the compensation rule is to just give benefits that really are just a disguised referral fee. And so the benefits are part of the compensation. So if the compensation looks like it's fair market value, which is the general accepted amount that is kind of the going rate, but the benefits are just not fair market value, very excessive, and then there's a lot of referrals going on, then a government investigator would presume that that the benefits are part of the compensation and that there's being fee for referral there. So the idea behind these rules is that the compensation can't be tied to referrals, which is you're just going to be paid on how many patients you see. Well, see more patients, you get paid more. So that there's an incentive there to potentially for fraud and abuse, right? And so that's what that rule refers to. And like I said, the benefits are part of the compensation. I think from a negotiation standpoint, you kind of not want to know like where you are in your life, what is important to you. So I work with a lot of on the physician side, negotiating against the employer. So like I said, I've been on both sides. I've represented the provider, but I do represent a fair amount of physicians kind of entering their first contract. And, a lot of things are different to a lot of people depending on what stage they're in their life. Health insurance, someone who's starting a family, that's going to be maybe more important. Paid time off, vacation. I find that seems to be a bigger thing in people's minds now, is kind of having a better kind of lifestyle in terms of a work-life balance, if that exists. Car allowance, continuing education is a benefit, having that paid. And so that's something you want to think about before you kind of start negotiating. And we'll get into some other terms later that we'll talk about, where you can kind of weigh terms that may not be the best, but you're willing to take because you're getting a benefit. And that's kind of part of this negotiation. So one area, kind of going right into it, is the non-competition provision. I get a lot of questions on this clause, also referred to as non-competes. So are they legal? There's one in my contract. And basically in California, they're basically unenforceable. And kind of the public policy behind that is it just prohibits people from working, especially in an area, I'm not sure where all of you are, but like in Southern California, basically probably any metropolitan area in California or any other state, if you have a non-compete in place, which is basically a contractual provision that says you can't work in the same position within a 5-mile, 10-mile radius for a certain amount of time. And so if you live in a metropolitan area, that will really cut down on your ability to work. You'd have to relocate somewhere. And so the public policy behind that is, we don't want to do that. We don't want to prohibit people from being able to work. And it kind of potentially could inhibit competition. So they are enforceable in very limited contexts. For example, if you're selling a business like a medical practice and you have an ownership interest in that, you can, as a seller, restrict the buyer, or vice versa. The buyer can restrict the seller from just like opening shop down the street. And so that's in place so that you don't have, someone that you bought the practice from and then they're opening up a practice right across the street from you. So it's a lot of very, very limited context. But from what I mostly see is employers include them as a way to sort of almost kind of intimidate the employee to thinking, okay, gosh, like I have to really be committed. And if I leave, I can't be competing with them. And so my advice a lot of times is if you have other areas of the contract, for example, the benefits we just went over, or the compensation that are really, really important to you to negotiate, which usually those two things are some of the top things to negotiate. I would say just you could even leave this in because it's not enforceable. So when you leave, the employer says, aha, you can't work at the clinic that's 5 miles down the road, which could be in a completely different town. That's really not enforceable. And they would not have any luck trying to legally enforce that. And they probably know that. On the other side, if you're an employer, and maybe some of you are, or you will be someday, including in the contract can also expose you to liability, because if you have it in the contract, because you're using it as a mechanism to have employees think that they can't compete, that could potentially be in what's called an unfair competition lawsuit, which is basically a very broad law that prohibits businesses from engaging in any anti-competitive activities. And so this would be one, is including an illegal provision that prohibits competition, even though it's completely illegal, would on top of that be illegal for the employer. So, but my advice to you is if you have one in your contract, is to really think about if there's other areas to negotiate, is to perhaps just leave this in. If you have other parts of the contract that are more important for you to negotiate. The other non-solicitation provision. Now, a lot of people get the non-compete and the non-solicitation confused. The non-solicitation provision is enforceable. Okay, and so what this clause is it prohibits you from soliciting employees, patients, physicians, anyone at the practice that you're leaving. You're going to the new place. You can't just bring folks with you. Say, hey, I'm starting at this new practice down the street, and I'm gonna bring all the medical assistants with me. You don't even need a non-solicitation provision in the contract. That's illegal under state law anyways. But a lot of times employers include a non-solicitation provision, and it's really targeted towards keeping the patients at the practice. So where this isn't really a key for you is physicians have a professional obligation not to abandon their patients, right? We all know this. And this is where these two, the non-solicitation provision and your professional obligations sort of butt up against each other when the time comes for you to leave. And I've dealt with lots of cases on this where, either a group of physicians are leaving, or maybe it's one, and there is a lot of contention around where the patients go. So the rule is the patient decides where they go, right? Okay, well, how do they know? So the way the patients know is the physician who is leaving, the one who has the obligation not to abandon the patient, has to give what we call a patient notice. And I've seen some agreements include the patient notice in the employment agreement. It's pretty rare, but I have seen it. But it's basically a letter to the patient saying, dear patient, Dr. So-and-so is going to be leaving. They're going to this new place. If you'd like us to transfer your records there, let us know. If not, they will be maintained here at the practice. So that's where you get the practice wanting to keep the patients there. They'd probably rather not give the notice, versus the physician leaving who wants all of their patients to come with them. And so I see a lot of disputes over this. I had one that comes to mind where the physician group, it was 4 physicians. My client was the founding physician, and the other 3 were leaving, and they were not leaving on good terms. So the physicians that were leaving, we had like a settlement agreement with a retired judge to kind of hash it all out. We came out with a deal on, this is kind of how it's all going to be split up. And we decided that there would be this notice to all the patients, and the parties would work together on what that would look like. Well, before we could even get to drafting that, a couple of days after our settlement meeting, the 3 departing physicians, who weren't my clients, by the way, in the dead of night, downloaded all of their patient records. And that completely derailed the settlement. We almost sued them over it. So even if they're your patients, the patients, the records belong to the medical practice. And that's the custodian of those records. And the proper way to notify the patients is to do a patient notice and then have the patient decide. So the reason why what these 3 physicians did was wrong is that they were accessing patient information not for a medical reason. So we had a huge, privacy violation as well. And you're thinking, well, they're their patients. Well, you can look at your patient records for medical reasons, billing, and all sorts of things like that. But to download them onto your own unsecure computer, I think they even had them on their phones and stuff, really caused a problem, and made their exit a lot more painful than if they hadn't done that. So the takeaway from that is, if you're the departing physician, really advocate for yourself on that patient notice to make sure first of all, try and have the employer pay for the notice. It's not really that expensive. It's just mailing it to all the patients, but make sure it has, where you're going, the address, the phone number, where they can reach you. It offers to transfer your records, and they do have to sign a release. Include that release, make it as easy as possible for the patient to fill it in. And then make sure that the old practice where you're leaving, if patients are calling there, they're being notified also on the phone, like, oh, Dr. So-and-so has left. Here's the new place. Do you want us to transfer your records? And that'll hopefully keep it as seamless as possible. But this is a really big area that I like to point out to physicians, because you can't solicit the employees, the patients, and the physicians, but you do have an obligation to notify your patients where you're going. So it's, so these 2 can be in conflict sometimes. Okay, expense reimbursement. This is not compensation. This has to be paid. So I would advise you just to, make sure the contract doesn't have any kind of restrictions on this, on what the procedures are, but this would not be considered compensation. Continuing education, this is usually a cost that you have every year. I find most, especially if you're an employer and not an independent contractor, which we'll get to that in a second, but employer, I think almost always will cover, they'll usually set aside what I've usually seen as an amount, and then you just use that how you want, and you send in to get reimbursed. So if you want to do the week-long course, educational course in Tahiti, you might not get all that paid for. But this is one that I typically find from an employee standpoint is paid for. Okay, the next, another big area that I get a lot of questions on is the malpractice insurance. So we all know we have to have malpractice insurance. If you're an employee, the employer should pay for it. What I would want you to take away from this is, again, we're talking about when you exit, but it's just so common that folks move different places. So, and that's where we see all the, when the contract, when people finally look at it, is, oh, the person's leaving. Well, what are the obligations, right? So you're all happy, you sign it, you start working there, everything's great. But then when it's time for you to leave for good, bad, or whatever, that's where people start looking at the contract and saying, well, what's really required? And so my advice is know ahead of time. Don't wait until you're at your exit. But the exit point is usually where we will see all these issues come up. And one very common example is tail coverage. And I'll just quickly go over what that is in case there's folks who don't know. But there's two types of malpractice coverage. There's occurrence policies, which is lifetime coverage for incidents that occur during the period, regardless of when the claim's reported. So you could have left, right? You're at your new place and you get a claim from a patient at the old place. The occurrence policy will cover that. Okay. Most don't have that because that's really expensive. So what they instead have is what's called claims made policy, which covers incidents that happen and are reported within the policy timeframe unless a tail is purchased. So this is the more common. This is probably what you have because it's substantially cheaper for the employer. Like I said, most employees aren't paying this. So the reason why the tail coverage is important is because the claims made only covers it during that period. So if you work at the practice from, let's say, 2018 to the end of 2020, and then 2021, you're at a new place, you could get a claim in 2019. I mean, set aside statute of limitations and all that stuff, right? We know that people can just bring claims. If you have a claim brought, there's insurance coverage. It doesn't matter what the legal defenses are. So if a claim's brought from that prior period, if you didn't purchase a tail, it's not covered under the claims made policy. And so most physician employment contracts will indicate whether or not they cover the tail coverage. So in my experience, it's like half the time they cover it, half the time they don't. You want to make sure you know either way, because I've seen contracts where it's vague, and I tell my clients, just know either way. Vague just means, well, when you're going to leave, of course, the employer is going to say, well, no, we're not covering that because you're leaving. Have it set out whether or not they're covering it or not. And if they're not covering it, realize that that's a tens of thousands of dollars in an insurance policy you need to buy when you leave. So either the new employer needs to pick up that, again, we call it a tail, either the new employer picks it up, which is going to be a negotiating thing when you go to the new place, or you will, which is very expensive. So my advice is to make sure you know in the contract whether it's covered or not. If it's not covered and you haven't signed the contract yet, see if you can get it covered. I mean, I would advise that the employer be on the hook for that, because especially if you haven't been there a very long period of time, it's not going to be as expensive as if you were there for many, many years. And so just that's my advice on the tail coverage. The other important advice is confirm you're covered with a certificate of insurance. I had a client who, a physician employed at a practice, when it was time for her to leave, the contract said that they covered tail coverage, that they paid for the tail coverage. So she was like, oh, great, because I'm going to a new place, so you need the tail coverage. And then she found out the employer actually didn't have a certificate of insurance, like didn't have her on the policy, which was a huge, huge exposure. We ended up getting it worked out. But my advice is have something in the contract that says that the employer will provide you with a certificate of insurance, which is it is what it says. It's a certificate, but it's a legal document you can rely on that you have that insurance. And the same thing with the tail coverage is to make sure you have that document so that again, I think it was a rare occurrence that the employer didn't have them listed, but if you have it in the contract that that the employer is supposed to provide that to you, that's some additional protection from you. And if the employer says, oh no, we don't want to do that, that's a huge red flag and I wouldn't want to work there. But it should be very basic that they they provide you with a certificate of insurance. And so including in the contract should be a no-brainer for them. If you're going to be working as an independent contractor, we'll talk about the distinction in a second here, then you'll have to obtain this tail coverage. And again, that you should think of that in terms of your negotiation, because you're paying all these expenses. So typically you would have a higher rate. Okay. Arbitration provision. So, and just to kind of quickly go over arbitration in case there's folks that don't know what it is, you might have heard the term, but it's basically you're waiving, if there's a dispute under the contract, the parties are both waiving going to court. So instead they're going to go to arbitration, which is a private forum where the parties choose either a retired judge or a lawyer to hear the case. You still kind of prepare everything as if you're having a trial, but you're not, the main thing is you're waiving the right to a jury trial. There's a lot of limitations on this in the employment context, and the law's been changing a lot. And there's like federal arbitration provision, and then a lot of the states have come in, especially California, to try and chip away at that, which is more pro-employee. So if you're on the employee side, a lot of times the mandatory arbitration provision can't be mandatory. Now, I find that physician disputes often are better litigated in an arbitration provision because they usually have a lot of complex issues. But really, it's just something you want to think about. Is it almost always is going to be included or offered in an employment agreement that you sign. And in terms of whether or not it's enforceable, that's usually on the employer's liability, because the employer is usually the party that's trying to enforce it. So usually the employee is saying, well, I was required to. They wouldn't hire me unless I signed this. In which case a court may say, well, that's not really fair. That was mandatory. It's not enforceable, and they can file their litigation in court. So just something to think about. We kind of touched on these before, some of these negotiating tips. Like I said, most people just think about the number, like what's the compensation going to be, but it's really this whole package. You have to think about the benefits, the malpractice insurance. Are they paying for tail coverage? Are they not? Are they paying for CE? Making the notice period long enough or short enough, right? If you're an employee, 6 months seems to be a long amount of time to work at a place if you have another job. And again, the new place may not want to wait 6 months. So these are just things to think about as kind of move on your career path. Then I said we were going to we'll cover kind of real quickly the employee versus independent contractor. Most providers in a practice are employees, and people that that want to be independent contractors, or a lot of times it's the employer who's trying to avoid paying taxes. So the liability there's on the employer. They are the ones that pay the payroll taxes. And it really comes down to, there's a lot of components to this, and the law's kind of recently changed on it. And physicians are kind of in this group where they're the most easily identifiable as independent contractors. But that being said, it comes down to one of the components is who controls the worker. If the practice controls their employee, if the worker controls, they're an independent contractor. It's a very simplified version, but one example could be you're going to be working at a practice as a physician, and they said, okay, you're going to work here 5 days a week from 8 to 5, and then you get a certain amount of like coverage on weekends, and you get this vacation time, and they're basically telling you when to be there, and so on and so forth. That would be an employee. Independent contractor is, we're gonna bring you on sort of this temporary basis, and you tell us kind of what your schedule is going to be and fit it in, and you kind of, as the independent contractor, take on a lot of those employer costs. And usually you have your own, you've either done your own incorporation or sole proprietorship or something. And so that's kind of one difference. Who determines it? The government, of of course, there's a lot of agencies, the IRS, tax, EDD, which is the Employment and Department of Labor. So there's a lot of entities out there because from an employer side, for any employers out there, future employers, if there's been a wrongful classification, then you would owe payroll taxes going back, right? And so you have multiple employees. Some of these claims get up to be, several. They could be, tens of thousands of dollars, possibly more. And the government has a tendency to find that the person's an employee, because then that's more tax dollars. So anyway, there's many different requirements to sort of fit in, but the general one is employee. That's where most people fall. In California, even more people fall into that because there is AB5, a recent law that came out, kind of counterbalancing another case law that came out. And but there's a lot of exceptions to it. Physicians are one. So just again, something to sort of think about. And that's kind of what I have on physician compensation. I just wanted to highlight a couple of other contracts that you may come across. Provider agreements. So that's when you're getting credentialed with Anthem or a health plan or something like that. That's another contract for consideration, is to going through the whole credentialing process. Billing and collections. So if you have like a third party biller, again, this is more if you're on the ownership side, you would enter into, usually an agreement with the billing company. Leases, and those, again, leases are something that's also covered by the federal anti-referral and anti-kickback statutes, especially if you're leasing space from another provider. So a lot of times those need to be vetted by a healthcare lawyer. Marketing is very highly regulated on the physician side, not necessarily the marketer, but marketing can get a little tricky. We usually advise, flat fee, because if you're paying, you can't be paying for referrals. And so that's where marketing can get a little bit tricky. And so, and also just, I have a lot of clients that say, well, they're doing my marketing and I just don't have an agreement, because they think, well, it'll be easier if I just don't document, what the compensation is. And that usually doesn't work, because then it's just based on actions and you don't have what the actual compensation is. And so if it's based on the actions, a lot of time it's not compliant. And the presumption from a government investigator's perspective is usually going to be that you have a violation of one of those statutes, the anti-kickback statute in particular. So not doing a contract because you're concerned that what you would document would be illegal is usually problematic either way. So I would urge you to have marketing, any kind of marketing contract or marketing, employees that are going to do marketing, kind of run that compensation structure by a healthcare lawyer. And like I said, the contracts we went over have kind of similar requirements to the employment contracts we talked about, including independent contractor. So the Stark and anti-kickback laws also have an independent contractor exception. So it's not just a bona fide employee exception. There's also an independent contractor exception. So independent contractor still needs to document the arrangement with the practice, document their compensation structure. Still needs to be a 12-month term in writing, signed by the parties. That's actually one that I have to mention, because so many clients, they pay for all this work to have contracts done and then they don't sign them. I mean, it's an easy fix, but it's just, you don't want to be signing a contract that was drafted 2-3 years ago. And also the other thing that I've been kind of bringing up more and more often to clients is to make sure these stay updated. So you enter into a contract in 2017, and then 4 years later, there's been no updates. That might be okay, but typically compensation has changed, benefits may have changed. there's probably been changes that you need to do amendments to the contract to bring them into compliance, or to make sure they're, to confirm that they're still in compliant. And they get clients saying, well, how I get it, there's all these exceptions, there's these rules, it has to be all documented, but where does this come up? And it comes up in a variety of ways. So probably one of the most common is, a Medicare audit. Could be just a run of the mill. We want to just look at these codes. We want to look at these records. And then on the claim forms, you've got the rendering provider, the billing provider. You've kind of got different providers going on. And I'm dealing with one right now where Medicare said, well, and they actually issued a subpoena, which is a little bit scary, but they want to look at all the contracts, every contract for every provider. And this practice has, 20 providers. So they're going to be vetting these contracts. So it comes up more often than you think. Another way that I've seen it come up is patient complaining to the medical board or the osteopathic medical board saying, well, the patient or the doctor, they complain about, let's say like a billing issue, or the doctor said that this was going to help me, but it didn't, right? Just kind of your classic patient complaint. The boards are focused on protecting the public. So if a patient's just complaining kind of buyer's remorse type of complaint, which I see a lot of, the board typically doesn't get involved in those. But where I have seen those go sideways is the board says, okay, let's look at the records, let's look at the bills. And then they want to start looking at, well, and then what's the structure you have of the practice? And then, okay, it was this, nurse practitioner was treating the patient, and what's the agreement with that person? And then they start, the government investigator, and this would be a state board investigator, start wanting to know, well, basically wanting to look at what makes up the practice. And so you have just a typical patient complaint just morph into this, larger investigation. And I have one going on right now where like the practice actually closed 2 years ago. But because of the pandemic or whatever, the complaint process is a little bit delayed, but they're still looking at all this stuff, and they want to look at contracts and corporate documents. And so it does happen. Government investigators get into this stuff. Some of the private insurers try to, but they don't have so much, they don't have the ability to subpoena that kind of stuff. So they don't often get as much into it, but definitely the government investigators know that, if you haven't set up the proper compensation structure, it can be a stark violation, which is an anti-referral statute, or kickback, like either of those statutes, or state. Remember, there's state versions as well. And so, like I said, either the penalty is, well, we're not going to pay you on the claims you submitted in the past that are pending, or we're going to ask for money back on what we did pay because your contracts weren't compliant, your compensation structure wasn't compliant. That's kind of the minimum, on up to their civil monetary penalty for the kickback for these statutes. And then it goes on up to criminal. So there's a lot of liability on the way these arrangements are structured. And so, it's important, kind of in conclusion, it's important to make sure that your contract is vetted. And like I said, my intention here was to kind of highlight areas that I frequently see when I talk to clients, and like I've been on both sides. And it's always recommended to have a healthcare lawyer look over your contract, make sure it's compliant, so that you're protected. And so with that, if anyone has questions.
Well, we do have a question in the chat.
Okay.
It's from Michael Stein, and it's where would moonlighting fit in, and what can you share on that?
Oh, okay. Yeah, I mean, it's going to depend on what the contract says. So what I have seen is I had a client that was going to be working at a practice, but was still going to keep like they had some kind of position at like a hospital-based clinic or something like that. And so we made sure that their employment agreement kind of carved that out. So yeah, that's another good point, is to make sure that if you are going to be, having, providing services elsewhere, because a lot of times your general contract will prohibit that. This is general prohibition, like we're bringing you on, you're working for only us. And so if you are going to be working somewhere else, you want to have that addressed in the contract. Otherwise, you could be in breach of the contract. So it's not going to be a non-compete problem, because remember, that's generally not enforceable. But yeah, that's where you would run into that. Does that answer that?
You said great, thank you.
Oh, yeah.
Does anyone else have any questions? You can raise your hand and or unmute, and just please feel free to ask Kathy. I don't see any hand raising or anyone unmuting. All right, well, I guess that's it. Thank you very much, Kathy, for joining us today and putting this together for us.
Yeah, no problem. Yeah, if anyone, you have my contact information right there, feel free to share the slides. If something you think of a question later, I'd be happy to chat by email.
Perfect, thank you. Thank you all for joining us.